Assalamualaikum and hi, my name is Nur Aminah Nandila bin Muhammad Nazri. My matric number H21A2366. Definition of company. A company is a legal entity formed by a group of individuals to engage in and operate a business. Commercial or industrial enterprise. A company may be organized in various ways for facts and financial liability purpose depending on the corporate law of its jurisdiction. Section 2 CA 2016. Company means a company incorporated under this act or under any corresponding previous written law. Section 3 CA 2016. Corporation is any body corporate, formed or incorporated or existing in Malaysia or outside Malaysia and includes any foreign company, limited liability partnership and foreign limited liability partnership. Section 9 CA 2016. A company shall have a name, one or more members having limited or unlimited liability. In the case of company limited by shares, one or more shares and one or more directors. There are four classifications of a company. First, based on liability of members. Liability of members divide into unlimited company and limited company. Second, based on public status and divide into private company and public company. 3, based on relationship with other company and divide into holdings and subsidiary. And 4 is based on place of incorporation and divide into local and foreign.
Hello, my name is Aminah Bidujai, matric number H21A2064. Firstly, the classification of a company. A company is based on liability of members, which is divided by two, such as a limited company and limited company. A limited company defined under Section 10 subsection O as if there is no limit on the liability of its member. For example, its member or shareholder will be personally responsible for the full extent any losses incurs. Moreover, either a private firm or public company must comply with Section 11 subsection 3. Hence, Section 12 does not require share capital. It's rarely used at trading firm, mutual fund, and asset trade investment. As such, a limited company distributes profit to shareholders. Example of a limited company is sole proprietorship. This is because it has only one owner and its liability is unlimited. For example, personal income or asset of the owner will not be protected if the company is declared bankrupt or in debt. Therefore, for limited company are divided by two, which is limited by shares and limited by guarantee. Section 10 subsection 2 define limited by share as liability of its member to the amount, if any, or unpaid on share held by the members. The liability of the members depends on whether his shares are fully paid or not. If fully paid, so it has no further liability in the event of the company and being wound up or to pay the company debts. Secondly, limited by guarantee. Section 10 subsection 3, liability of its member is limited to such amount as the member undertake to contribute in the event of its being wound up. Therefore, company limited guarantee does not have share capital and does not require the member to contribute to the share capital.
Hi, my name is Na'mani Nadira binti Muhammad Zamir and my number matric is H21A2362. So I want to present about the basic on public status. The first of the basic of public status is private company. So the any business that immediately before this act to in fact qualify as a private corporate under a matching privately writing legislation, and any business that under section 41 is transformed into a private corporate. For the example, private company such as Malaysia Airlines, Nines Bigmart and Mardin. For the second basic of public status, which is a public company. The definition of a public company is a company other than a private company raises funds from the public, therefore subjective to more regulatory control whether by the CA or other legislation than the private company. Characteristic of a public company is it can be company limited by share or guarantee. It can also be an unlimited company. It can have more than 50 shareholders and it has no restrictions to transfer its shares. Thank you.
Hello and greetings everyone. My name is Irene Gusi Anak Sidi and my matrix number is H2A2099. Now, my part is based on the relationship with other company. There are two types of it. Among of them are the holding company and subsidiary company. But first, I will explain about holding company. Holding company, also known as the parent company or holding corporations, is a type of business entity that owns and controls other companies, called subsidiaries. The main function of holding corporations is, or holding company is to exercise control over its subsidiary by making strategic decisions, providing capital, and overseeing their operations. By owning the majority of shares in subsidiary companies, the holding company has the power to appoint the board of directors and influence important decisions. It may also provide financial and managerial support to its subsidiaries. The second one is subsidiary company. Subsidiary company, also known as a subsidiary, a company that is controlled and owned by the parent company or holding company. The parent company typically holds a majority of the subsidiaries' voting shares or stock, giving it the ability to exercise control over the subsidiaries' operations and strategic decisions. That's all for me. I will pass to the next slide to the next presenter. Thank you.
My name is Bong Wen Ying. My matching number is H21A2016. Based on place of incorporation. Firstly, local company. In Section 2 of the Code of Appeals, company incorporated pursuant to this Act or to any correspondent previous written law. Secondly is foreign company. In Section 2, a company, corporation, society, association, or other body incorporated in Malaysia. A foreign company desiring to carry on a business in Malaysia is required to register as a foreign company under the Act, Section 561. Promoters and pre-incorporation contract. Any contract or transaction entered by a company before its incorporation, usually entered by promoters. Next, the effect of pre-incorporation contracts under common law. A company cannot enter into a contract before it is incorporated. The reason for this rule is that before its incorporation, the company has no legal personality and no contractual capacity. Lastly, the effect of pre-incorporation contracts under the Companies Act 2016. Nevertheless, in Section 65 of the Court of Appeals has overcome the difficulty under the company law by allowing the company to ratify the contract created before its incorporation. Once the pre-incorporation contract is ratified, a distant in-law is bound by the contract and is entitled to the benefit of the contract from the date the contract was made retrospectively. Section 65. The person who acted in the name or on behalf of the company to make the contract will be personally bound by the contract and entitled to the benefit thereof.